Thank you for coming today. I'm attorney Gloria Allred, and I'm going to be making a statement, and then Michele is going to make a statement, and then my co-counsel, John Carpenter, will be making a statement. And then I'll take some questions. Michele's not going to be taking any questions. And we will provide you with a police report and our claim. On March 14th, 2020, Michele was a guest at the Pechanga Resort Casino and was staying in room 10470 on the 4th floor of Tower 1 by herself. Michele planned with a friend to go to a concert and stay the night at Pechanga. Due to COVID-19 related concerns, her friend declined to go. Michele thought it would be safe to go to Pechanga alone and kept the room reservation. When she arrived at Pechanga, Michele was the only guest registered in room 10470 and the only guest who had a key card issued for access to the room. Michele spent time on the casino floor and consumed alcoholic beverages. At approximately 11:15 p.m., when Michele started feeling intoxicated, she attempted to return to her room at the casino, room 10470. Surveillance video from the elevator showed Michele was having difficulty keeping her balance. Notwithstanding her intoxication, Michele made it to her room, 10470, safely. When she arrived at her door, she attempted to use the key card that she had been issued earlier that day. However, Michele's room key card did not work. Instead of unlocking the door, a yellow-orange light appeared on the key card pad, falsely indicating that the room had been locked from the inside. Michele walked to the elevator lobby and called the front desk for assistance using the guest phone. She spoke with a supervisor, who informed her that a new key card would be brought to her. The supervisor noticed that Michele was intoxicated. After speaking with the supervisor, Michele went back to the door of 10470 and waited for a working key card. Nobody came. Michele went back to the guest phone near the elevator and again asked that a working key card be brought up to her. She then went back to door 10470 and waited for a working key card. A Pechanga employee saw Michele sitting on the floor in the hallway by her door. In a statement given to law enforcement, the employee indicated that he recognized that Michele was intoxicated. That same employee came up to Michele and asked if there was a problem. Michele explained to him that her key card was not working and gave her card to that employee for him to try it. He confirmed that the key card was not working and informed Michele that the blinking yellow-orange light on the door's key card meant that someone was inside the room, had locked the door from inside the room, and was preventing access to the room. He had Michele confirm multiple times that she was alone at the casino and that no one else could possibly be in that room. The thought that someone could be in her room, however, frightened her, because the employee who told her that was an employee of Pechanga, and because she was frightened that there might be someone in her room, Michele entrusted him with the information that she had traveled to the resort by herself and was staying in the room alone. Thus, the employee used his position as an employee at the hotel to obtain the information that Michele was alone and that no one else was in her hotel room. In fact, the door to Michele's unit was not locked from inside the room. Based on law enforcement investigative records and the interrogation report for the door locked to room 10420, the key card panel was malfunctioning, preventing Michele from safely entering her room on her own. Based upon law enforcement reports, it was known to Pechanga that the key cards, pads, were known to malfunction. Nevertheless, they were negligently maintained and/or repaired. Pechanga Resort Casino and its employees failed to take reasonable steps to ensure the safety of guests, including Michele, by negligently maintaining and/or repairing the resort's key card system, including the door lock to room 10470. After some time, the supervisor arrived with another key card. According to a law enforcement report, the supervisor also recognized that Michele was intoxicated and having difficulty standing up. The employee physically assisted Michele in standing up because of her level of intoxication. The supervisor informed her that the key system often malfunctioned. He gave Michele a new key which she used to gain entry to her room. The supervisor and the employee then left after Michele entered her room. Michele prepared to go to bed. She heard a knock at her door. Upon opening the door, Michele found that the employee had returned to her room unaccompanied by any other Pechanga employee. Michele asked why he was there. She had not asked for any further assistance, and she wanted to go asleep. The employee knew that Michele was alone in her room. Because Michele was preparing to go to sleep, she was partially clothed. The employee then repeatedly pressured Michele to let him into her room by asking her multiple times if she needed anything. He finally gained access to her room. Instead of giving the obviously intoxicated guest some water from the minibar, the employee needlessly removed a champagne bottle from the service minibar. Based on a BarTech printout, a purchase is made from the minibar whenever an item is removed from its location. As such, the employee caused the purchase of additional alcohol to the already intoxicated Michele. He then proceeded to pour Michele a glass of champagne, despite knowing that she was intoxicated, describing her state to law enforcement later as, quote, wasted, end quote. Next, Michele recalls finding the employee on top of her as he was sexually assaulting, battering, and raping her by having non-consensual vaginal intercourse and other non-consensual sexual contact with her. Due to her known intoxication, Michele was incapable of giving legal consent to the employee for any sexual contact pursuant to Penal Code Section 261, parentheses, A, and parentheses, 3, end parentheses, of the California Penal Code. Michele yelled for the employee to get off of her. However, according to the police report, the employee did continue to engage in sexual conduct with Michele. After the employee left her room, Michele promptly called the front desk and reported the incident. She informed the employee who answered the phone that she had been raped. After security and law enforcement arrived at the scene, Michele was transported to Temecula Valley Hospital. The Riverside County Sheriff's Department developed an incident report, and a sexual assault response team nurse confirmed injuries to Michele's vaginal area and bruising of Michele's breast, consistent with bite marks. Michele has fully cooperated with the criminal investigation and fully expected that the district attorney in Riverside County would prosecute the accused employee based on her statements to the Riverside sheriffs, her injuries, and the employee's statements to the sheriffs, including the fact that he knew that she was intoxicated and, quote, wasted, end quote, when he engaged in sexual acts with Michele. However, to Michele's shock and surprise, she was recently informed that the district attorney has declined to prosecute. No reason was provided for the refusal. Given the facts and circumstances alleged in this incident, we urge the elected district attorney of Riverside County, Michael Hestron, to explain to the public and to Michele why his office refused to prosecute. It is against the law in California and in many states to engage in intimate sexual conduct with a person who is under the influence of, as a result of alcohol and/or drugs. In fact, in Pennsylvania, Bill Cosby was prosecuted and convicted of drugging and sexually assaulting Andrea Constant, and he is still in prison as a result of having been convicted of that charge. A person who is under the influence cannot consent as a matter of law to sexual intercourse or oral copulation, and any person who knows or reasonably should know that a woman is intoxicated should be prosecuted if he proceeds to have sexual intercourse with her. It is very traumatic for any woman who alleges that she was raped to speak to law enforcement, then undergo a rape kit, and then to have her case declined for prosecution without being given any reason why prosecution is declined, especially in a case where a victim has indicated that she's willing to testify, and where the accused admits to law enforcement that at the time of the sexual interaction, he knew that the victim was intoxicated. In addition to our demanding answers from District Attorney Hestrin, we are also filing a claim today against Pechanga Resort because of what we believe was their negligence in this case. We're seeking damages for Michele in the amount of $10 million. Michele has been willing to come forward today, not only because of what she suffered, but because we have reason to believe that there are many rape cases in California with similar facts that are not being prosecuted. In other words, women who become intoxicated often become victims of sexual violence while they are under the influence. Because they often feel shame and blame themselves, they do not speak out when prosecutors decline to prosecute their case. We are very proud of Michele's courage in coming forward to provide a voice for victims. And it's time for prosecutors who decline prosecution to support the rights of victims and let juries decide in a court of law if the accused is innocent or guilty, rather than shutting the courthouse door in the face of the victims. And now I'm going to present Michele.
I'm obviously very nervous right now, so bear with me. Hello, everyone, and thank you for being here. And thank you to Gloria and John for all of their support, as this has been a very difficult time for me and my family. I've recently gone through the worst time of my life. It is hard to express in words everything that I've gone through, as it's very traumatizing and affecting every aspect of my life. After the sexual assault, I was a wreck dealing with feelings of anger, sadness, depression, shame, and disbelief. And the only consolation I had was that I put my faith in the Riverside DA's office that justice would be done. However, I was wrong, very, very wrong, as I received a call telling me the DA's office was not going to prosecute. I felt like I was in a dream, and I couldn't even speak. I had to get off the phone immediately. I was in total shock. I felt like a zombie for hours, and then the shock turned into despair and hysterics. I had such a pain in my chest, I thought I was having a heart attack, that my family was about to take me to the hospital. I was inconsolable for days, not being able to get out of bed, but eventually I got the strength to get up, and despair turned into anger, which continues today. I could not comprehend how and why the DA was not prosecuting. I was raped. Sorry. And taken advantage of while I was inebriated. The person who raped me was an employee at Pechanga. And because he was an employee, I put my trust in him, believing that he would act in the best interest to help me. Well, the only thing he helped was ruining my life. After being victimized by him that horrible night, I was then victimized again by the DA's office when I was told they weren't going to prosecute. I am furious, I'm confused, and I am depressed by all of this. Unless you have gone through something like this yourself, you cannot imagine how hard it is to come forward in the first place, and then to basically be told by the DA that he will not seek justice for you. Sorry. This is obviously a very sensitive situation for me. The decision to speak out today has not been a rash one or without the support of my family and friends. There's no way I'd be able to be here today without that. Their support gives me the strength to stand up to Pechanga and to the Riverside DA's office and to say that this is not okay. The decision of the district attorney's office not to prosecute tells women to believe that there will not be justice for them. This is an insult to all women who have been sexually assaulted and a travesty of our justice system. It was not easy to come forward in the first place, and it's definitely not easy sitting in front of all of you today. But there's no way I'm going to allow Pechanga and the DA's office get away with this, and I'm not going to be silenced. Thank you.
My co-counsel, John Carpenter.
My name is John Carpenter, Zuckerman, and Rowley. Thank you, Michelle. Since the murder of George Floyd, we as a community have been talking about justice more than any other time in our lifetime. We talk about justice, we pray for justice, we protest for justice, we demand justice. But no one's talking about how you make justice. And as someone who's been fighting for justice for 30 years, this formula for justice is simple. Take the time to learn the truth and treat the truth with the love and respect it deserves. If you treat the truth with indifference, the opposite of love, what you get is injustice and unrest. Whether your name is Breonna Taylor or Michele, when the truth is brought to you and it's ignored, you don't get justice. I'd like to take this time on behalf of Michele to thank the people of the Sheriff's Department of Riverside. They did an excellent investigation. This employee, Pechanga, at first said that he went into the room just to help her open up the refrigerator door, and then he left without incident. Michele then reported her rape, and the Sheriff's Department investigated. They spoke with Michele, they heard the truth from her, and then they spoke to the Pechanga employee. And when they spoke to the Pechanga employee, they found out some things. They found out that when this employee first saw Michele, he identified her as having trouble standing up. He identified her as being wasted. Her speech was slurred. He laughed at her because she was drunk. And she was so drunk she couldn't figure out how to open up the refrigerator door. She was trying to open it from the wrong side of the refrigerator. So the detectives brought this truth to the district attorney, and it was ignored. This is not a he said, she said situation. Michele says she was raped. The Pechanga employee admits that he knew she was intoxicated. And the law says that when you're intoxicated, you cannot consent to sexual conduct. And we're here to say that if you're so drunk you can't figure out how to open up a refrigerator, then you can't consent to sex. If you find someone laying in the hallway who's intoxicated and you find a way to have sex with that person, that does not make you a man. That makes you a rapist. Plain and simple. So it raises the question of what influence does Pechanga Resort have over the district attorney's office to cause them not to prosecute this clear rape? The district attorney's office says they have no such influence at all. So to test that, we're asking the Pechanga Resort to join us in our request to have the district attorney prosecute the Pechanga employee. If the Pechanga Resort joins us in this request, we'll see how much power Pechanga has. If they refuse to, we'll know that Pechanga is not safe for women or anyone else, and none of us should go there. Thank you.
Michele is not going to be taking any questions. I'll take some questions, or if you have questions for John, I'm sure John will be happy to answer some questions as well.
Gloria, what is the status of this employee at Pechanga? What is his title there? And was he seen on camera going in and out of the room? Does he have any type of record, history of doing this, or any type of record at all?
Okay, we can't speak to whether he has a history of doing this or not. We don't have information on that at this time. In reference to your question as what does he do at Pechanga, we are providing you with a police report. We are not providing his name, nor are we identifying him in any way in reference to what his job was at Pechanga. I will tell you that there does not appear to be any dispute about the fact that he was on that floor, that he did go to assist Michele, and that he did return to the room, to her room. When I say no dispute, he waived his Miranda rights and agreed to speak to and give an interview to and answer the questions of the Riverside County Sheriffs. So we are providing you with a copy of that police report redacted in order to essentially to at least some extent protect the rights of the accused, and with the hope that the district attorney of Riverside County will review his decision not to prosecute and decide to prosecute. We did inquire as to the reason that they were declining to prosecute, so at least we could provide Michele with that information. No reason was given. I think if there's going to be a declination or prosecution, the least any DA could do would be to give a reason to the victim so she would understand. But no reason was given. So all I can tell you is there is no dispute he was an employee, had access to the floor, had a reason to be on that floor, but as far as we're concerned, had no reason to be in her room. And there's no dispute that he knew that she was intoxicated or wasted.
Are you able to say what is the status of employment there?
I don't know the status of his employment there at this time.
Gloria, did the DA contact your client by phone, by mail? How did that work?
The district attorney conveyed the message through her counsel that there would be there was a declining of the prosecution. My understanding is since they learned that we were going to do a press conference today, that they may now be reviewing the file again. But we were clear on the fact they were declining prosecution, and that is why we're doing the press conference.
Let's go back to it again. Telephonic or written?
On the telephone, to her counsel.
How long did the call take?
I don't know how long the call took. It wasn't with me. Okay.
Have you had any contact with the Riverside County Sheriff?
No.
Somewhat concerned about this.
As I say, we have no criticism whatsoever. The Riverside County Sheriffs, they did a great job in investigating, so no. Obviously, it was referred for prosecution by the sheriffs, otherwise the DA wouldn't have had it at all, because sheriffs are not required to, if they think there's not sufficient basis for prosecution, are not required to refer it to the district attorney.
In the experience that you've had, and her counsel have had, when such matters come forward, is there usually a written explanation asked for as to what the grounds are for declination of prosecution?
I can't answer the question as to whether internally the district attorney's office internally makes a note of why they decline prosecution. I can just tell you that it's been my experience as a women's rights attorney for 44 years that often, and most often, there's nothing in writing that is given to the victim. Often she will get a call either from the district attorney or a victim's advocate who works for the district attorney's office, telling her they've declined prosecution. Sometimes they give a reason, sometimes they don't give a reason. Sometimes they give a vague reason that's meaningless to victims, like, we don't think we can prove the case beyond a reasonable doubt, which is our burden. No reason was given here. I think, if victims go through reporting, doing a crime report, speaking to law enforcement, going through a very often painful rape kit test, and when they're still upset and they've been raped, they should at least be given information as to the reason if its prosecution is later declined, particularly where a victim is willing to testify, and particularly where there appears to be an admission by the accused, which is in a police report, to certain facts that are key elements of the law that could be applied in the case.
Is the suspect a tribal member?
I don't have information as to whether the suspect is a tribal member. I don't have any information to answer that question.
Has there been any difficulties in terms of sovereignty?
Well, the question has to do with any difficulties in terms of sovereignty. The answer is yes and no. The district attorney does have jurisdiction to prosecute the case in Riverside County as opposed to on the tribal land. However, in order to file a claim, we must proceed according to the tribal rules to file a claim, which we are doing today. And we have those rules and we are following them, meaning we have to file a claim within 180 days. And that's what we did today.
Are the authorities in the tribal council, is there a formal setup like a city or county government?
Do you mean for the decision in reference to the claim?
That's right. I know.
Okay,
Don't worry about it.
I do.
It's the way.
I do. So I'm sorry, if you wouldn't mind, just pull it up a little, thank you. All right, so, I'm sorry, now what was your question?
The question is, when you're talking about tribal law, what kind of a governmental establishment is there at tribal law? Is there a council? Is it a formal setup like county government, city government?
I'll let John, do you want to answer that question? Okay, hold on. Here, John.
There's a tribal act that provides for a binding arbitration with a retired judge through JAMS. And when you are injured on tribal land, you don't have the same rights that you do if you're injured here anywhere else in the United States. And so you don't have access to the courts. In fact, if you happen to file a claim against the perpetrator, you lose all rights. But the process is you file a claim within 180 days, and then they go through the tribal process with the binding arbitration, and you have very limited rights of appeal.
By doing that, can the tribal council, if they make a determination that the claim is valid, give authorization to Riverside District Attorney to go ahead and prosecute, but they would not stand in the way or object?
The tribe and the casino has no rights to interfere with, no formal rights to interfere with the prosecution. Whether they're exercising their authority and their position as donors or otherwise to stop the prosecution, we don't know.
We don't know whether they've given any kind of, call to the DA's office to say, sorry, don't go ahead with this.
We don't know that. That's why I'm asking for them to join in our call to ask for prosecution.
Meaning they have as much to lose as your client does, if not more.
Well, you would think they would care about the safety of their guests, yes.
Is there any licensing for gambling there that right on any of this when they have get a record like this, or any that apply to this?
Well, California law generally applies for safety rules, but it's a casino, right?
Gloria, can we talk about the DA? They have many concerts there, many music festivals and stuff like that where people gather around and get together. Has anybody, other women approached you, similar circumstances that this might have happened to? Are you open to hearing other people as well? That the DA has turned down, if there's any record of the DA doing this, denying for Pechanga instead of the victim?
I actually don't keep those kinds of records, but I generally just keep records of the cases that I accept, and if I don't accept a case, it doesn't mean that it lacks merit, just means there may be many reasons for it. But I can just tell you, just based on my experience, and I'm not talking about Pechanga now, I'm talking in general. The way the system works is the district attorneys